There is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loper Bright.
Welcome back to American Mindset, the channel where we defend freedom, honor our values, and call out the nonsense that threatens the principles this great nation was built on.
Let me tell you, this video is a must-watch because it exposes some cracks in the foundation of how our government operates and raises some serious questions about the rule of law in this country. So grab a coffee, sit back, and let's break this down together. And don't forget to hit that subscribe button and turn on notifications so that you never miss a moment of truth, my fellow patriots. Let's watch the video.
A legal answer, it depends.
On what?
On the nature and circumstances of the case before us.
So there are certain circumstances that would cause you to recommend to the administration that it defy a lower court order.
Well, Senator, for example, in some circumstances, in order for a court order to be challenged, an official must be held in contempt. And so, yes, it is possible that we could get there. However, I would be remiss were we to go down the path of talking about hypotheticals because, as I say, I can never imagine a situation in which I would be asked to give that advice.
Chairman, thank you for your generosity with my time. I appreciate it. Thank you all.
Senator Kennedy.
Thank you, Mr. Chairman. Gentlemen, I don't want to spend a lot of time on this, but I also don't want to debate how many lawyers can dance on the head of a pen. I think you understand where a lot of these questions are coming from. Mr. Geiser, would you ever advise a client to ignore a federal district court opinion?
Thank you very much, Senator Kennedy. I would advise it.
Thank me. You can thank me by answering it.
I would advise a client on how best to comply with all lawful court orders.
Is that a yes or a no?
Yes, sir.
You would advise a client not to follow a federal district court opinion?
I would advise a client to follow court orders.
Would you ever advise a client not to follow a federal court of appeals decision?
I had the privilege of clerking on 2 federal courts of appeals.
Is that a yes or no?
Yes. I would advise them to follow the orders of courts of appeals.
How about Supreme Court opinion?
Yes, Senator, I would advise them to follow the Supreme Court's orders, as President Trump has been very clear that those orders are to be followed.
Mr. Woodward, let me ask you the same question. Would you ever advise a client not to follow a district court opinion?
No, Senator.
Would you ever advise a client not to abide by an opinion of the Federal Court of Appeals?
No, Senator. Again, it's difficult to answer in the hypothetical, but...
Would you ever advise a client not to follow an opinion by the United States Supreme Court?
No, Senator. As the President has been clear, he will follow all orders of the United States Supreme Court.
Tell me what I would need to do under the APA, the Administrative Procedures Act, if I want to change a current rule.
Well, Senator, as a senator, you would pass a law that would change the...
No. I don't want to play games here, Counsel. What would one have to do? What would the head of an agency have to do to overturn a current rule or regulation?
Well, Senator, I apologize. I know that there are many ways to do that, and I don't want to play games either. I want to answer the question.
That's fair.
There are many ways in which an agency can overturn a rule.
Well, you have to give notice, right?
As a general matter, yes, Senator.
Yeah. And you have to invite input, right?
As a general matter, yes, Senator.
Okay. And sometimes you have to hold a hearing, right?
Sometimes you do, Senator.
Yeah. Are there any exceptions to that under the Administrative Procedures Act?
Under the Administrative Procedures Act, I'm not aware of any exceptions, but there are exceptions under the law.
Okay. Are you familiar with the good cause exception to the Administrative Procedures Act?
Senator, I am vaguely familiar with that exception.
Okay, do you know what it says?
No, Senator, I do not.
I understand. Here's what I'm driving at. Are you familiar with the Supreme Court's case called Loper Bright?
Senator, I am vaguely familiar with the Supreme Court's decision in Loper Bright.
The Overturn Chevron doctrine, right?
The Chevron deference doctrine, yes, Senator.
Okay. If there is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loper Bright, ruling unconstitutional the Chevron doctrine, would it be possible, strike that, would it be prudent for the Justice Department to exercise authority under the good cause exception to the APA in the public interest and forego the rule, the notice and comment?
So, Senator, thank you. I think I now understand your question. And that is I was alluding to the non-APA process. I mean, if a rule has been promulgated that is plainly unconstitutional, it absolutely would be appropriate for the Department of Justice to look at that rule and make a determination.
My point is, you don't have to ignore the APA to do that, do you?
I would say it depends, but I take your point.
I mean, the APA provides an exception.
Yes, Senator.
It's section 553. It's right there, big as Dallas. Am I done?
Yeah.
I thought that was maybe a mouse or something.
Senator Cool.
Thank you, Chairman Grassley, Ranking Member Durbin.
Now, let me set the stage for you. Senator John Kennedy, the Lion of Louisiana, a straight shooter if there ever was one, grilled these judicial nominees, asking them some very simple, straightforward questions. And yet, their answers were anything but simple. The first question Senator Kennedy asked was this: would you ever advise a client to ignore a federal court order? Sounds like a no-brainer, right? The answer should be a resounding no. But instead, what we got were these dodgy, overly complicated responses. One nominee, Mr. Geyser, said he would advise his clients to comply with lawful court orders, but his tone and hesitations were, let's just say, less than convincing. What's going on here, folks? Why is it so hard for these people to just say, yes, I believe in upholding the law? Are they afraid to commit to the rule of law? Or is there something deeper going on? Now, let's talk about nominee number 2, Mr. Wood. When Kennedy asked him the same question, would he ever advise a client to ignore a federal court opinion? He gave a more straightforward answer. No. But here's the thing, patriots. Even when they say they'll follow the law, you can't help but feel like these answers are scripted, like they're just giving us what they think we want to hear. And that brings me to a bigger issue. The role of judges and lawyers in this country is to uphold the Constitution and protect the rights of the American people. But when you listen to these nominees, they sound more like bureaucrats than defenders of justice. They're tiptoeing around basic principles, and that should concern every single one of us. Now, Senator Kennedy didn't stop there, because he's not the kind of guy who lets people off easy. He shifted gears to talk about the Administrative Procedures Act, or APA. For those of you who don't know, the APA sets the rules for how government agencies can create or change regulations. Kennedy asked these nominees a simple question: what steps does an agency head need to take to change a rule? And guess what? They fumbled that too. They admitted that agencies have to provide notice, invite public input, and sometimes hold hearings. But when Kennedy pressed them about exceptions to the APA, specifically the good cause exception, they were clueless. Now, here's why this matters, patriots. The good cause exception allows agencies to bypass the usual red tape if there's an urgent need, like protecting public safety. But these nominees didn't even seem to know what it was. How can we trust these people to uphold the law when they don't even understand the tools at their disposal? Then came the bombshell moment. Kennedy brought up the recent Supreme Court case, Loper Bright, which overturned the Chevron deference doctrine. Now, if you're not familiar with Chevron deference, it's this idea that courts should defer to federal agencies when interpreting ambiguous laws. Basically, it gave unelected bureaucrats way too much power. But the Supreme Court said enough is enough and struck it down. And you'd think these nominees would be thrilled about that, right? After all, it's a win for accountability in limited government. But when Kennedy asked whether the Justice Department could use the good cause exception to bypass APA procedures and get rid of unconstitutional rules, the answers were vague and evasive. Why is it so hard for these people to just say, yes, we'll do what's right? It's almost like they're afraid to challenge the status quo, like they'd rather keep the swamp intact than drain it. So, what does all this mean for you and me, the everyday Americans who just want to live our lives in peace and freedom? It means we need to pay attention. Patriots. These judicial nominees are the gatekeepers of justice. And if they're not willing to stand up for the Constitution, who will? Senator Kennedy did a great job exposing their weaknesses, but it's up to us to demand better. We need judges and lawyers who believe in the rule of law, who aren't afraid to challenge unconstitutional rules, and who will fight for the rights of the American people. Before I wrap up, let me leave you with this. The questions Senator Kennedy asked were simple, but the answers revealed a lot about the state of our legal system. We need leaders who are clear, decisive, and committed to the principles that make this country great. If you agree, hit that like button and share this video with your friends. Let's get the word out, patriots. And if you're as fired up as I am, drop a comment below and tell me what you think. Do you trust these nominees? What would you ask them if you had the chance? Thanks for tuning in to Rising Daily. Together, we can hold the line and fight for the America we believe in. God bless you, and God bless the United States of America. See you next time.